Welcome. If you're just joining us, we're going to give it a couple minutes, let some people get on the line here. Thank you all for joining us for Next Act. We'll get started shortly. Okay, it looks like we got a good number of people coming on the line here. So I just want to welcome you today. Thank you all for joining us for our webinar on Next Act, Connecting International Job Seekers to Opportunity. My name is Camille Bradbury, and I'm a legal content specialist from Bridge, here to facilitate and host our session today. I'll start by going over some housekeeping items, provide a brief intro regarding what Next Act is all about, and then I'll introduce our presenters on the line. A couple of housekeeping items to keep in mind. This session is being recorded, and afterwards, registrants will receive recording of the webinar with additional resources, so watch for that in your email. Everything we present today is meant to be educational and shouldn't be used in replace of direct legal counsel. Your phone lines are muted, and if you have any questions, you can ask them in the Q&A feature found at the bottom of your Zoom screen anytime during the presentation today. If your question has already been asked in the chat feature, go ahead and give it a thumbs up. That'll upvote it to the top, and we can make sure to answer the most popular ones. We will save about 25 minutes at the end of the webinar to answer questions live. If your question doesn't get answered today, we will also be following up with additional resources, including an Ask Me Anything live session for legal counsel to answer more of your questions. So watch for that too. This webinar is hosted by Bridge. Bridge is a full service immigration provider to companies of all sizes. By combining the unique strengths of purpose-built software and best-in-class legal experts, Bridge helps companies execute efficient and organized immigration processes that are proactive and informed, while providing a superior experience to international employees. Over 450 leading companies across every major industry and geography have relied on Bridge to handle immigration needs from over 170 countries. Bridge's mission is to make global mobility frictionless in order to help companies achieve their talent goals and empower individuals to become global citizens. Now, during the COVID-19 pandemic, many of you joining us today are international professionals who have been affected by sweeping layoffs or who are faced with a change of status. During this crisis, many companies are also actively hiring for international talent. So Bridge, in partnership with Unshackled Ventures, Upworldly Global, and startup founder and investor James Richard, took action to help connect international employees with those employers. So essentially, Next Act is through Bridge's website, international employees can sign up to find their next act, and employers can request that list to make their next hire. Through this program, affected international employees will also get free ongoing resources, including connection to sponsorship-friendly employers who are actively hiring, webinars and legal consultations to explore immigration options, digital skill building tools built for immigrants, and introductions to VCs that predominantly fund immigrant entrepreneurs. The response from both candidates and employers has been tremendous since we launched. We've had more than 350,000 impressions across channels, and more than 600 growing companies have been contacted, with impressed recruiters pouring through the talent on our Next Act candidate list. Now to introduce our organization and presenters on the line with us today, we have expert legal counsel from ImmiPartner, here to discuss some options to consider in terms of visa types, and the founder of Unshackled Ventures, who can offer visa sponsorship support and entrepreneurial resources for the international community. Start with ImmiPartner is one of Bridge's partnering corporate immigration law firms, grounded in over 2 decades of in-the-trenches experience managing thousands of business immigration cases. They are focused on saving companies, entrepreneurs, and investors time and money by simplifying the U.S. immigration process, leveraging attorney experience, and delivering transparent case processing through Bridge's software solution. So we have Hendrik here representing ImmiPartner. Hendrik is the co-founder of ImmiPartner. He brings over a decade of immigration legal experience and has been certified by the California Bar as a legal specialist in immigration and nationality law. Hendrik has worked as a corporate immigration lawyer at the highest levels, having managed hundreds of early-stage technology companies and their immigration programs. Hendrik has also represented many investors and entrepreneurs seeking to enter the US. And we've got Unshackled Ventures is also on the line. Unshackled Ventures is a pre-seed venture capital fund for immigrant founders and startups. Along with investment capital, the fund provides full immigration support, including visa sponsorship. The fund is industry and vertically agnostic and has made approximately 50 investments in teams with immigrant founders, solving problems in industries like healthcare, space, education, food and agriculture, wireless infrastructure, industrial manufacturing, and more. As a high conviction investor, Unshackled prefers to lead and be the social signal others follow. Companies funded by Unshackled have gone on to raise more than 100 million in follow-on financings. Manan Mehta is the founder of Unshackled Ventures on the line with us today. Prior to Unshackled Ventures, Manan ran marketing for edtech startups No by Intel in 2013 that raised over 90 million of funding from top VCs, including A16Z, First Round Capital, and Floodgate. Before No, Manan was an investment banker with 3 billion in transactions, including the 1.9 billion acquisition of Skype. Manan was born in Silicon Valley and received a double major at UCLA. And I'll now turn it over to both of them and join you again at the end of the webinar to host our Q&A session. Go ahead, Hendrik.
Great, thanks so much. And it's a pleasure to be here today. So with the time, there's obviously a lot to cover. With the time today, my aim really is to remind everyone of some key timelines to keep in mind, to raise a few unique COVID-19 related pointers to keep in mind, and then also to briefly discuss and leave everybody with a list of various immigration status options to consider, and then to dig into deeper to try to find a solution for your particular situation. So again, thanks everyone for tuning in. This is definitely timely and exciting for me to be able to help out. So okay, so let's dive in here. So just as a starting point, let's talk a little bit about key timelines. Many people are aware of these, but just to make sure, for those who are laid off, one of the key rules and kind of the timeline that sets unfortunately the pressure that the immigration system has created for individuals is based on a 60-day grace period that follows termination. So if you're, and there's questions about when this starts. So if you're notified today, for example, that in 2 weeks you're going to be let go, then the 60-day grace period starts in 2 weeks when you are no longer working in that role itself. So it's also important to note that the 60-day grace period assumes that everybody has, or that you have at least 60 days left in your authorized period of stay, so your I-94. If you have less than 60 days, then that date actually controls. So something else just to note there. From a timeline standpoint, it's also for individuals who are in F1 status and on OPT, for example, there's also the additional element of allowable periods of unemployment. So if you're in OPT, there's a 90-day period of allowable unemployment, and that jumps up to 150 days of cumulative unemployment that you can have if you're in STEM OPT. So you have to keep those unemployment and that's cumulative, so that unemployment total in mind, in addition to then also knowing about the 60-day grace period. So it's I will note that proving this kind of the 60-day window and what you have that you've kind of abided by the 60-day window is really an after-the-fact determination made by the Immigration Service when you are filing your subsequent application or once you found a solution. So, you need to be prepared to prove that you have stayed within that 60-day window. And we'll talk a little bit about some discretion in a minute, but it's just important to keep that in mind. Usually pay stubs are submitted, other forms of proof to show that you've kind of met that burden. Now, what does this 60-day grace period mean? So if within the 60-day grace period, you are allowed to change status to another status type. You are, and we'll talk about some of those options. So if you're on H-1B, maybe you decide to get, to study and get on an F1 or to find an O1, if an O1 is available to go that route. Or if you find another employer, then you can certainly, have your H-1B transferred to that new employer. So those filings have to happen within that 60-day grace period window. You do not have to get an approval within the 60 days. This has to be filed. If you do not do that, then technically after the 60 days, you start accruing what's called unlawful presence in the country. And the problem there is that could then trigger some bars to future reentry and cause other issues. So that's kind of the standard rule. I will note, as a result of COVID, the USCIS, so the Immigration Service, on their website, they released essentially a reminder. This has always existed, but a reminder that they do have the discretion to accept filings that are beyond that period of time. So late filings, for example, so they are allowed to accept late filings, and in their discretion, that's a decision that they will make. So it's worth noting that obviously best practice, you want to stay within that 60-day window. But it is worthy of note that they have, again, reminded everybody of this, of this discretion that they have. Now, one other, COVID, it's not COVID specific. This doesn't come out as a result of COVID, but it's something that is being brought up and kind of we're also thinking through more than we normally do, is something from an Obama era regulation that was passed. That is related to requesting work authorization based on compelling circumstances. So I just very briefly wanted to note this. It's certainly worthy of additional discussion and research. Kind of the gist of this is that if you are an individual who has gone through a certain phase of the green card process, in this case, if you made it through the I-140 stage of a green card process, and you either are in a particular non-immigrant visa status, like an H-1B or an O-1, or you're within the 60-day grace period after termination, then you are allowed to request a work card based on compelling circumstances. So the obvious question is, well, what qualifies under compelling circumstances? There isn't as bright line of a rule as we would like, and there usually is not a bright line rule, unfortunately. But I do bring it up because on the one hand, they do indicate that merely being unemployed does not rise to the level of a compelling circumstance. But there is mention, they discuss some examples of scenarios, and there is one particular example discussed there as what might qualify. And the scenario there that they use is an employee who loses a job due to a closure of a business, where that individual has been applying a technical skill set in a high-tech industry, and where the individual can show that this high-tech industry doesn't really exist, or there's just not much opportunity in one's home country. So I bring it up because it's certainly something to consider. This is certainly not the argument to hang one's hat on as this is going to be my solution, but it's something to keep in mind if either you have the I-140 approval and you can make this argument, to have it kind of in your back pocket and to discuss further to kind of round out a strategy that will be pursued. So those are a couple of kind of unique COVID related items I wanted to mention. So now let's turn to some of the more common solutions that are probably better solutions to try to strive for, keeping those other items in mind. So we can start with the H-1B. If one is in H-1B status, you can certainly transfer to another H-1B employer within the 60-day grace period. Again, it's 60 days as long as you have at least 60 days left on your I-94 or your authorized period of stay, which you got when you either entered the U.S. or is on a recent approval notice that you received. So you need to be very mindful of those dates. If you transfer to another employer, you are allowed to start working with that new employer upon receipt by the Immigration Service. So a couple of key points there. And for those not really familiar with the H-1B, it's a professional worker visa. There's unfortunately a quota every year. So usually you're not able to just file for an H-1B with an employer unless they satisfy certain criteria to make them kind of exempt from this quota. But it's professional worker visa. We have to show that it's a specialty occupation, requires at least a bachelor's degree, and then you as an individual have that particular bachelor's degree background. So kind of in a nutshell. It is worth noting that H-1B, it can be filed as a part-time application. So there's no requirement that an H-1B be full-time. There can be a range of hours stated. So that sometimes gives some flexibility. It's also possible to have more than one H-1B. So there's the option for concurrent H-1Bs if there's a couple of part-time roles, for example. So there are some, there's some flexibility in how the H-1B is used. So just wanted to mention that. Now, just one quick question that also comes up is, what if I find the employer and I can file my case and it's just past that 60-day grace period window? Again, coming back to the discretion, the Immigration Service is allowed to accept late filings. So again, trying to explain and make an argument why this was filed, a little bit after that grace period window is certainly possible to attempt. Again, it's discretion, so it's not guaranteed, but you can certainly put together a strong an argument as you can there. And then also on the H-1B front, although it's typically a little bit more challenging, the H-1B can be used in kind of an entrepreneurial context. There are employer-employee requirements that need to be established, so that gets into setting up a board of directors and kind of doing the best you can to show there is still some employer-employee relationship. I just want to throw that out there. It's challenging, but it is possible as you kind of think through options. So that's a little bit on H-1B. Moving to the F-1. So, and this is applicable if you are currently in F-1, you might be working in OPT status, STEM OPT, or you're considering switching to F-1. Or you're on F1, you're in OPT, and now you're considering enrolling again in a degree program because you're working with a company on OPT, and that has now ended. So a couple of points. Again, OPT holders have up to 90 days of unemployment that they can accrue before having to leave the U.S. If you go over that 90 days of unemployment, then you are no longer maintaining status. You're also not eligible for that 60-day grace period in that case. As a reminder, if you have STEM OPT, then it jumps from 90 to 150 total days. So these timelines are critically important to keep in mind. So what do I have to do to not be considered, unemployed in terms of OPT status? So a couple of points there. ICE, the Immigration Customs Enforcement, has stated that a student must work at least 20 hours per week in a qualifying position to be considered employed. So, obviously for OPT, or not obviously, for OPT, you have to be working in an area that draws upon the skills that you gained in your course of study. That's the basis of the OPT. So you have to be working at least 20 hours. Now, for OPT, it's important to note that there is a lot more flexibility than there is if one is on STEM OPT. So for OPT, for example, one does not necessarily have to be working as an employee. There is more flexibility there. So that's something to consider. It's more, some individuals on OPT will pursue some entrepreneurial ambition that they have, and it's a good time to do that. Or they might be in more of a volunteer type role, although that's something that needs to be kind of carefully considered because for each state, there may be some employment law issues there. But OPT generally is more flexible. For STEM OPT, they actually discuss wages being paid that are commensurate or in line with others in the field. They actually specifically talk about proving employer-employee relationships. So there's less flexibility when you get to the STEM OPT stage, if that's even available to you. And STEM OPT is for those who have a degree. There's a listing of STEM fields where you can extend your initial 12-month OPT period. So it's also important as a reminder to work, if you're in that situation, to work with your school and with the DSO at the school to make sure you maintain, a clean CVIS record. So that's also very, very key. Now, again, as I mentioned, one can apply to change into F1 status. To do that, one has to obviously find a degree program, enroll in the program. You are then issued an I-20, and with that, you can actually file to change status. Individuals that are in F1 can also re-enroll in a new course of study. So that is so that's certainly an option worth considering. Again, timelines are critical, right? Can you find a program, be enrolled in the program, get an I-20, get your case, depending if you're changing status or just continuing on F1. There are going to be timelines that you need to be cognizant of there. So that needs to be kind of well planned out and thought out. Okay, so we'll turn to the O1. So the O1 visa option is an ability-based visa. So the focus on the O1, the majority of the focus is on you as an individual, what you have done in your particular area of work, what kind of acclaim have you gotten, have you separated yourself from others in the field. I will say that in my experience and my view is that the O1 is underutilized. I think individuals a lot of times don't, for whatever reason, see themselves in that light of having some, really proven ability. And the O1 approval rates are relatively high compared to other visa types. And I think that there might be some kind of policy reasons for that. Also, there's fewer people applying for that, and people kind of self-select out, unfortunately, sometimes. So just wanted to put that out there, that it's worth exploring. I think most people should explore that as an option. So the way the O1 works is that there are the immigration rules provide us a listing of criteria that we can focus on to prove that you have separated yourself from the norm in the field. And we have to satisfy at least 3 of those. So just, as an example, showing that you have a membership in a particular organization or association in your field, and that membership, there was some application and review process that you had to go through to be admitted to that group. If there has been any published material in trade publications, newspapers about you and your work, or it could even be about some project or company. If we can then show that you had some lead or critical role with that project or entity. Taking a look at salaries that you've received in the past can be a way to also show that you've separated yourself from others, and we compare that to kind of government statistics. And this can be in the U.S. These can be achievements that we're using from anywhere in the world. Participation on panels, if you've been invited to be a speaker, and any written work or research that you have done as well. So there's various different criteria that we can run through to try to see if we can satisfy at least 3 of those. So that's another option to consider. And again, within that 60-day window, if there's an opportunity that for an O1, let's say you were not selected in the H-1B lottery, and you're running out of time, and STEM OPT, maybe O1 is an option depending on how much work in your field you've done, before completing that degree program, for example. So something worth considering. Okay, so, and I realize I'm running through these pretty quickly. I just want to kind of put these out there. So again, you can have something to kind of a list of options to kind of run through, and then to follow up for more discussion. So we'll move ahead to one that is often kind of more of a entrepreneurial option. It doesn't have to be, but a lot of times it's utilized this way, is the E2 visa. So this is a treaty-based application. And the idea there is that if you hold a passport from one of the countries listed on this E2 treaty, then you are allowed to apply for the E2 as an investor or as an executive of the company. You have to prove that you've already invested or you're actively in the process of investing and creating this E2 qualified business. You're coming in to kind of direct or develop the company. Again, that's one option for the E2. The company itself has to be at least 50% owned by either yourself or between yourself and others from that particular treaty country. So it's essentially a U.S. business that's set up. You can actually purchase a business as well and take that business over and operate it. But you have to show ownership at least 50% from treaty country nationals, and then obviously explain investments that have made or are going to be made. Business plan is required, and kind of what you're going to do with this business and how you're going to grow this viable business. So just wanted to mention that. There is also a L1 visa. So that's an option for multinational executives and managers or individuals with specialized knowledge. This is not really a short-term solution, but something to keep in mind. I say it's not short-term because you need to show that you have worked in one of those positions for at least 1 year out of the last 3 years before applying, and that you are now coming into the U.S. to either run a related U.S. entity, so a subsidiary, parent, an affiliate company in the U.S., or you are now going to set up one of those companies in the U.S. that's related to the non-U.S. entity you worked for. So there's a lot more there, but that's kind of the rough idea. So some people actually kind of plan to see how that could happen. Or if you haven't been in the U.S. for long and you did work for an entity outside the U.S. in one of those role types, you might still, from a timing standpoint, be able to make that happen. Then, something that has come up is the visitor visa status as well. So we'll move to that briefly. Typically, changing to a visitor visa, let's say from a student visa or from an H-1B, is typically, it can be problematic because the idea with the visitor visa is you're applying to enter for specific purposes and leave. So it usually conflicts a little bit if you're changing into that status. I will say though that given the circumstances, if you can show that there's travel restrictions, you cannot travel, there are health concerns, if you can make an argument for why you cannot leave right now, you realize you have 60 days, for example, but you have an argument as to why you cannot, or you really do not want to leave, and you can base it on COVID-related kind of fallout from COVID, then you could file to request a change to a visitor visa status, for example. That can be issued for up to 6 months at a time. It's going to take them several months to process the application. Again, as long as you file these application types within your 60-day window, then you are going to be able to stay here and wait. Obviously, no work authorization there, but it could be an option to buy some time and something to consider. So just a couple more here. I know I'm running up on time here. Obviously there are dependent visa status types as well. If for spouses on an H-1B, for example, you can get on an H-4. Usually not work authorized, but sometimes it is if the H-1B holder, for example, has gone to a certain stage of the green card process again. So it's an approved I-140 in that case. But that can buy some time. So that's nice if you have that option available. And then, green card filings. So something worth mentioning there. We've been talking about non-immigrant visa options. So just kind of as the last one, you can certainly file a green card application. There's usually a couple of different steps in that process, depending on which category you classify under. But and it also depends on which country you are from. So there are, green card backlogs. There's a monthly bulletin called the Visa Bulletin put out every month that kind of shows how these backlogs are shifting. But for some individuals in some categories, there is no backlog. If that is the case, let's say you're pursuing a EB-1A green card application, which is based on your proven extraordinary ability. If the Visa Bulletin says there's no backlog, there's no wait for this particular country, then you could file both parts of that process, the I-140 and the I-485, which is the actual request for the green card. You can file those together. So you file those concurrently. And by doing so, you are a pending immigrant, essentially. So you can actually request working authorization. You're allowed to stay in the U.S. So I just bring that up. It might be an option for some people. For other individuals, there are large backlogs and wait times, so it doesn't help because you are not allowed to file that last stage of the green card process, which which gives you these benefits. But certainly something to keep in mind as well. Okay, great. So I know that was a lot. Hopefully that gives some pointers and gives you something to think about as you're going through options. But I'll turn it over to Manan and the great program that they have at Unshackled.
Thank you, Hendrik. And that was. Can you guys hear me? Okay. All right. That was really helpful, and I think it's probably warrants a lot of follow-up questions. I look at the Q&A. Looks like you got your work cut out for yourself while I speak. So I'll let you go ahead and handle those. But for those that are kind of contemplating starting a company while on a visa, I think Unshackled may have a few perspectives for you. And as one of the founding partners, I can talk a little more about the options that are available. But I recognize that this is not necessarily every one of you on this call. I looked at the data. It looks about 33% of people have considered starting a company. And, as one of the founding partners, we've built this firm over the last 6 years. We manage about $30 million. I can tell you one of the most common reasons why a lot of immigrants do not start companies is because of immigration. And what I'm here to kind of tell you guys today and gals is that does not need to be the reason. Quick backdrop. We have invested in about 50 companies as Camille laid out earlier on. And we've done 130 immigration filings on behalf of our founders. What that means is we've considered everything that Hendrik talked about, from your O1 strategy, your EB1, your H1B, structuring the business from a employer-employee perspective, all the way down to J1s for trainee visas. The point I'm more or less making is that if you have an idea, if you are considering starting a company, we are in business to support you in doing that. So let me take a quick step back and give you some perspective on what that really means. So from the very early days of Unshackled, the ethos was based on 3 pillars, right? The first one was a lot of foreign-born entrepreneurs don't have access to friends and family capital. It's what's required to start a business in the country. It also plays really nicely when you're thinking about immigration and validating prevailing wage arguments. The second thing we recognize is that the difference between success and failure for a lot of foreign-born talent or immigrants is not what you know, it's who you know and when. It's very much of an insider game. And here in Silicon Valley, that's where I'm based. And so to the extent you can provide that network, you can help accelerate a lot of businesses. The third thing to do, if you're going to support immigrants, is to understand you have to support their immigration journey as well. And so from the very beginning of Unshackled, as one option, if you think about starting a company, is we actually structure the organization as an R&D technology lab. What that means is that we can actually invest, sponsor the visa holder, employ them, and allow them to build their company full-time. That's a huge benefit to what a lot of other firms are not able to do. As far as we're concerned, there's not a lot of venture funds or there's not any other venture fund that will go out of their way to systematically use their balance sheet to sponsor the visa holder. We recognize that's not for everybody. We have invested in now US citizens or permanent residents or green card holders. But at the same time, you cannot invest in the immigrant entrepreneur without supporting their immigration journey as well. So what does that mean, right? What does that mean in times like this? Here's what I can say from a very basic perspective. If you are somebody that wants to start a business today and you want to reach out to us, our average investment is about $300,000. We will use a lot of the strategies that Hendrik laid out, whether it be identifying the right visa strategy for you, filing for the appropriate extension, putting you on part-time wages, whatever is required to make sure that you can stay in the country legally and build your company at the same time. What I'll also say is if you are somebody whose time window is very narrow, reach out to us. We will prioritize evaluation and consideration on investing in you. For context, Unshackled invests at day 0. So for many of you who may be considering the entrepreneurial path, we recognize one of the biggest challenges is are you even allowed to incorporate your business in the US? It's one of the most common questions we are asked. 60% of our investment commitments have been before that company was even incorporated. So if you are on an H-1B visa and you realize that you need to articulate an employer-employee relationship, we can work with you on a very structured and practical solution to address that through a board of governors structure, or we can even become your employer to enable such a structure. A lot of this comes down to understanding your prevailing wages. Have you filed your I-140 for your H-1B extension? If not, we can initiate that. And we will also, in every case, initiate your green card process. So think about the immigration journey from initial work authorization to ultimately getting your US citizenship, if that's what you are interested in doing. Unshackled will take care of all of that at no cost, no legal cost to the entrepreneurs we back. We will invest in the company, our $300,000, that's to pay the wages, to let you build your development, to let you go out and do your business development as well. But none of that cost will go to immigration legal costs. That is our commitment to the immigrant entrepreneur. So to give you some kind of perspective, many of our founders have also been on F1 student visas. We recognize there's a difference between STEM OPT and OPT. And there's a lot of, rumors circulating in the market on what this administration is going to do or not going to do. We will work with your university student office to ensure that we can maintain your status. And if we understand that your OPT is expiring in a near-term fashion, we will quickly evaluate you for the O1 visa. I think what Hendrik outlined is that the O1 is a more palatable pathway than many people think it is. It doesn't mean you're guaranteed it. You just need somebody who's in your corner, who is willing to do the work and realize that immigration is not a one-size-fits-all strategy. So when we Unshackled get involved, we do not just say, all right, you're from X country, you have this education level, and these are your accolades, now go do this. We actually evaluate you for every single nuance that your situation entails. That's the only way you can actually solve immigration. It's almost like trying to find the right spouse. It's not like one size fits all. Immigration is very personal. So from a broad strokes perspective, again, happy to go into more details and more conversations about it. But if you go to our website, you'll see that we have a whole page dedicated to immigration on success stories, outcomes. We have done filings for over 50 people so far, 130 times. And very fortunately, we started this during the Obama administration, and we still exist during this administration. And we have 100% success in securing a visa outcome. One more thing to also understand, in the event, let's say, you're considering all your options and the H-1B doesn't work because you're a student visa holder currently, you don't win the lottery, a J-1 is not something that you can tap into, and you're not O-1 eligible. One of the things that we keep in mind is something called the cap-exempt H-1B. Cap-exempt H-1B is a type of H-1B that's afforded to universities or nonprofit research organizations. These are H-1B visas that are not part of the annual lottery. They're not part of the annual cap, and they are not time bound, meaning you have to file by April 1st and they go out in a certain timeline. These are something that if you can find the right universities, there's a number of universities in Boston and in New York, as well as here in California, in San Jose State University, that are willing to partner up with entrepreneurs, provide that employment, assuming they can get some funding, and give you a cap-exempt H-1B. In that scenario, what Hendrik was talking about, concurrent H-1Bs, all of a sudden become a lot more relevant. So you can actually be on multiple H-1Bs at the same time. And at Unshackled, we kind of use that as our catch-all strategy. We have yet to have to do it in 6 years. But in the event any of the visa strategies do not play out, we will work with whatever local university is by where you want to build your company to figure out a way for you to start your business and not have to leave the country. So that's just a quick framework. It's again, very high level. I'm very appreciative of the fact that immigration is very perspective and very personal. I am not an immigration attorney. I'm simply an entrepreneur who built a fund, so I don't try to give too much legal advice. I'll leave that to Hendrik, who's got the credentials to do so. But just note that what we come from is a perspective of how do we help you solve your problem so that immigration doesn't slow you down on building your company? Now is the best time to start a company. And Unshackled on April 2nd pledged to invest in 20 to 30 more businesses. We are actively looking at incredibly amount of deal flow. And again, if you are somebody that is under time constraints, you can go to our website, unshackledvc.com, fill out the pitch us form, and then email us and say, hey, my employment or my grace period ends on X date. Can you prioritize my evaluation? We will do it. We are built for scale. We are built for customer service, and we are here to help you start your company and create more American jobs.
Thank you so much, Manan. That was incredible information, and Hendrik as well. Really appreciate. We're going to save the last 20 minutes or so for Q&A. So we've had some that have come in and some that have come in prior to this webinar too. So I'll either pose it to Hendrik or to Manan, and we'll take it from here. The ones that we don't answer, we will follow up with additional resources and some FAQs. The first question we had come in was that I have been selected for the H-1B lottery, but my company did not file the petition since I'm not with them anymore. I assume I can't transfer this selection to a new place that I go. This one's for you, Hendrik. We're also getting a lot of questions about how do you transfer status in the middle of something? Can you go from H-1B to H-4? Can you simultaneously do 2 visas at the same time? If you can include that in your answer.
Sure. Yeah, great question, and one that certainly has been coming up a lot, unfortunately. So the H-1B. So this year was a new registration process, but the rules are still the same. That the H-1B selection is tied to a particular employer. So unfortunately, as the individual, you cannot take that H-1B cap selection with you. There are, some companies are still, and it's fine to still go ahead and file that H-1B cap application, because, for some companies, they would, they would love if come October 1st, from a business standpoint, they are able to actually bring the H-1B employee on board. Again, the H-1B for H-1B cap, once it's filed and approved, it only becomes effective starting October 1st. So if there's still a possibility that the company wants to have the individual start on October 1st, it's fine to go ahead and file it. That's certainly not a frivolous filing. There's no issue with that. And there are companies that are still going ahead and doing that. Now, there's kind of a number of questions that can come out of that in terms of, when can I transfer the H-1B or how that works? I mean, generally, if the H-1B is activated October 1st, and then thereafter there is a transfer to another employer, that certainly is possible. So you can transfer H-1Bs there, and this gets into a bit of a gray area. So arguments have to be made here. Usually, filing it before the H-1B has been approved or before October 1st can cause issues. So that's certainly something to dig into in more detail. But yeah, you cannot take the H-1B with you. In terms of some of the other questions that I think you mentioned, Camille, so you cannot have more than one status at a time. You can, however, have more than one case type pending at a time, but that can get a little bit complicated as well. So the Immigration Service follows a last action rule. So whatever the last action was or approval was, that is, for the most part, the status that you are in. Now, as Manan also referenced and I talked about before, it's possible to, in some contexts like H-1B, hold more than one H-1B, but you cannot hold 2 separate status types at the same time. So was there anything else, Camille, that I didn't address there that might be related?
There was one other one about filing, if 2 employers file O-1s at the same time. Can that get conflicting? For the
so the O-1's interesting. I mean, the O-1, there is an option. So for an O-1, you can you can be an entrepreneur filing an O1. You can be an employee filing an O1 or on an O1. Then there is actually another option, which again, there's nuance to it. So certainly speak to somebody about this, but you could potentially have an O1 where you have an itinerary of events, essentially. So if you have multiple projects or opportunities, there may be a way to structure the O1 to prove this is my particular skill set. I've separated myself from others by satisfying these criteria. And now I have, US companies that want me to engage in, these different projects. And you could potentially put a schedule of projects together. So that's oftentimes used in kind of, other arts and entertainment type industries, but there may be a way to structure that that would work to give you kind of some flexibility there. So the O1 is very interesting, again, underutilized, and I think absolutely something to dig into further based on, kind of what opportunities that you have.
Sure. Thank you so much. And to route back to H-1Bs, are H-1B candidates eligible for contract jobs?
Yeah, great question. So that relates directly to the kind of O1 option potentially. So H-1B, there has to be an employer-employee relationship for H-1B. And this is sometimes for like an entrepreneur, if there aren't, if there isn't kind of a really good strategy, as Manan kind of alluded to. This kind of comes up in that context as well. You need to be ready to kind of prove that out. Is there actually an employer-employee relationship? Is there an employer that is, that has kind of hiring, firing authority, that sort of thing. But yeah, you cannot, H-1B cannot be just based on contract jobs. So there has to be an employer sponsor.
Got it. And are H-1Bs eligible to file for unemployment?
Okay, yeah. So yeah, good question. As with most things, there's a little bit of gray to this depending on the state. So in general, unemployment benefits are seen as earned benefits. So it does make it possible for visa holders to receive them, where sometimes there's an issue, and this can be state specific, is it's kind of what the state requirements are. So some rules require the individual applying for these benefits to show that they are able and available for work should a work opportunity arise. And that sometimes can become challenging because a non-immigrant visa holder, is not necessarily just able and available to take on work that presents itself. So part of this answer is definitely state specific. The Department of Labor has a website where you can view state by state what the requirements are. Some states, including California, have actually taken some steps to ease particular eligibility requirements. So it's state by state. And just as a last note, to add another wrinkle to this, there is, now the Immigration Service has this public charge consideration, which they have instituted, for virtually, all application types. Unemployment benefits, may or may not cause issues, likely do not, but something to keep in mind and to look into. Any future applications, they ask if you have obtained any benefits. And this is also kind of, they take a look at kind of the totality of the circumstances. Have you gotten benefits in the past? What's your current situation? Are you likely to require government benefits in the future? And these can have some ramifications for future applications. So something to look into. So it's probably possible to get unemployment benefits depending on the state, and then just keep in mind these other issues to discuss further.
Sure, great, thank you so much. And Manan, this is for you and for Hendrik. Can you start a business under OPT work authorization?
Yeah, that's a good question. Yes, at least we've seen a lot of it. I think the bigger consideration that you should think about is OPT is probably the most flexible period you may have as a student that's been educated in the US. That said, OPT is not indefinite. And I try to remind entrepreneurs that, if you have the normal OPT, you may only have one filing window for an H-1B. But if you are a STEM OPT, you may have 3 filing windows. It all depends on your timeline and your preparedness. So what I recommend to those on OPT is, while it's a very fertile time to build something, to iterate, ideate, and validate what you're trying to do, it's in the back of your mind, think about your immigration strategy for when the next filing season opens up. If you don't have an employer willing to at least lob in a petition in the lottery, or your company is not in a position to lob for yourself, or you're not O1 eligible or EB1 eligible, or you have not figured out a solution, you may put your entire OPT stay kind of in a position where it was really great, but it didn't persist after it was done, right? Your entrepreneurial dreams do not persist. And so 100% start your company, but it's really important to come up with a strategy when you start it on what are the milestones you need to achieve. And at what point do you need to figure out, hey, it's December, my OPT expires in like 7 months. I better either figure out if I can get funded for this company, or if I can't, I should probably try to find a job for somebody who will petition and at least attempt to get my case selected in the lottery. So it's one of those things where you have to be constantly prepared, which is an unfair element to be an immigrant. I totally appreciate it. But this is the type of thinking that we try to bring, so that we recognize that solving immigration creates no business value. And so as a VC, we try to take that away and so that you focus back on building and selling your product. But 100% it's important for you to think about a strategy, though you can start a business on OPT.
Yeah, that's all. Yeah, that's all great, great insight. I completely agree with that. OPT again has more flexibility than STEM OPT also. So STEM OPT, there's training plan requirements. The rules specifically discuss employer-employee, proving a bona fide employer-employee relationship, which is possible, but again, it's just more tricky if it's your own your own company, or you have large ownership stake in the company. So absolutely agree. Have you need to have several backups at all times, and it is unfortunate. That's just the reality of the system. But yeah, so that's all good insight, and yeah, but you can do that on OPT.
Great. And Manan, there's another question that came in about, is Unshackled interested in supporting any particular industry sectors that they're looking to support right now, or do they only support IT business interests or people that want to be in that sector?
Yeah, it's a great question. So we are industry and vertically agnostic. We, because we invest so early, we actually mean when we say we bet on people. I can tell you right now, some of our biggest companies right now have pivoted their ideas 3 times. And so if you're going to bet on people, you have to be patient in that capital, and you have to be patient on letting them iterate on where they find that product market fit. So some perspective, we've done everything from plant-based proteins, so on the ground, all the way to cell towers in space and everything in between. So what we look for at a more holistic level is this a venture scalable business? That is a very loose definition when you see things like WeWork get funded or Sonder get funded, and I can totally appreciate it. But that said, if you go to our Medium page, we actually published what we think is venture fundable and how we look at the world. But that's the only real criteria that we look at is it venture fundable? Does an entrepreneur have a key insight? And then can we support them in that early journey of customer validation and customer iteration? And if so, then we'll do our part. So that's how we look at what venture fundable is. It's industry and vertically agnostic.
Sure. And then do you have portfolios of companies that are capped exempt or additional capped exempt resources?
From what perspective? What do you mean by cap exempt resources?
Let's see. Just getting the question coming in now. I might circle back to you. Sarah, if you want to reiterate on that one. Let's put a pin in that one for a minute and shoot back over to Hendrik when we get more clarification on that. Another question that came in was about OPT expires at the end of January 2021. Would a green card application filed now help them?
Take myself off mute, that might help. So yeah, possibly. So as you know, as we touched on a little bit, it's going to depend on. It's really looking at the timelines, right? So it's going to depend on which employment-based green card category you're qualifying under. So is it going to be EB1? And if so, is it based on extraordinary ability? Is it going to be kind of the more typical perm labor certification EB2 or EB3 application, meaning that you need a company to actually go through the recruitment process for the first stage of that application. So it really is kind of application type specific, but absolutely something to look into in terms of which of those options might you qualify for now, with or without an employer. And then kind of, do the calculation on roughly how much time might it take me just from a processing standpoint to get to the stage where I can actually file that request for the green card. So there's a process aspect to it. And then also really understanding, and they really couldn't have made it more complicated, but understanding kind of the monthly, what they call the visa bulletin that's put out, which is a chart. And again, they made it extra complicated because there's two charts, and some months you can use one chart versus the other, but really understanding how that works, because that gives you an indicator of how much of a backlog or a wait are you looking at before you can actually file that last stage of the green card process, assuming you've completed everything before that. And that's again a country of birth specific and category specific. But yes, if you if you are someone, EB1A for example, I'll just take that again. It's similar in a lot of ways to the O1 that we discussed. It's ability based. You have these criteria you focus on. For the green card, EB1A version of that, the burden of proof is higher, but it's similar in a lot of ways. So if you are from a country, and it's in terms of the shortest timeline, essentially, if you are not from India or China, unfortunately, this should ideally be something that nobody has any backlog for if you're extraordinary ability and you're contributing to the U.S. But that's another webinar probably. If you are from a country where there's no backlog, again, that means that you can actually file both stages of this process at the same time. Okay, so there's an I-140 where you prove your skill set essentially and what you're going to do and how you're going to apply that in the U.S. And then there's the I-485 request for the green card. So based on the timeline in the example, let's say January of next year, I think it was, you could certainly, again, you have to be, maintaining your current non-immigrant visa status, or, have some grace period you're working with, but it's absolutely worth considering because you could prepare and get a case on file. And as a result of that, also request work authorization, a travel permit, and the ability to stay. So yeah, so it's just dependent on the particular type that you're going for and your country of birth.
Sure. And just a couple more, Hendrik, posed to you. If I'm already outside of the U.S. and have been laid off, can I still re-enter the U.S.?
Okay, so it depends. I mean, for to be able to let's say you have an H-1B, you left the U.S., you're laid off. It's you need. If your H-1B visa is still valid, for example, and this is maybe getting the weeds a little bit, so happy to discuss offline also. But if you have a valid H-1B visa and you actually have a new offer of employment, and that has been approved, you can certainly enter using that that visa, even if it's a different employer. But you need to go through a new H-1B process. So that's just taking the H-1B as an example. If you don't have a valid visa that you can use, then, you're going to have to consular process something. Right now, the consulates are not operating. So you have this additional issue right now of, trying to get an appointment to process a particular visa type. So there's a couple of layers there. But if you are not employed, then you're not going to be able to enter, because when you enter and present yourself for entry into the U.S., you are saying, I'm going to use this H-1B, for example, with company ABC pursuant to an approved H-1B application. And if that's not the case, then you're not abiding by the rules of that visa type.
Okay, great. Thank you both for answering those questions. I just want to just give a big shout out to both of you for joining us today, and all of the international employees that were able to join us. Again, we'll be sending up follow-up resources. If your question didn't get answered, we'll have another Ask Me Anything to our legal counsel to answer more of your questions and give you more opportunities in the following weeks to get some more support during this crisis. So thanks again, and hope you all have a wonderful day.
Thank you all.
Appreciate you joining.